get something with the texting, that makes it more serious.
Sarah. Larson, okay.
Sarah Larson.
No, you're Larson.
I'm Larson.
No, Sarah. No. Want to speak?
Mhm.
I say, do you want to speak?
So,
Good evening, everyone. I'm Superintendent Elsie Arnson, and thank you for our third discussion of legislation that was passed in the previous session this last spring. Today, we're going to be discussing a bill that was brought and passed and signed by the governor regarding special needs children. It's a very unique bill. And I believe that's why we put it on today. It is about parents. It is about schools, but more importantly, it's about our children. And in this case, it's about those children in Montana that I believe have great strengths and need to be recognized. So with that, Jenna, I'll let you go ahead and discuss where we are and with some introductions. Thank you.
Yeah, good evening, everybody. Thank you so much for taking time out of your evening to join us. I will be helping moderate. So if you have any questions and you'd like to put them in the chat box, I will help our Chief Legal Counsel, Rob Stutz, as he goes through the bill summary for House Bill 393. So Rob, Rob, you're on mute. There you go.
Got it. Thank you. And thanks everybody for coming out this evening to talk about House Bill 393. This bill at its core is a program the legislature has established to provide for special needs equal opportunity savings accounts that allow for special needs students to receive an opportunity for reimbursement for funding of educational programs that they attend. If you've attended one of these community discussions before, welcome back, glad to have you. If you haven't, the process that I'm going to go through is we will look at the bill, and if you're not familiar with how to find bills or find statutes, we'll walk through that. There we go. There's our agenda. And we'll also be looking at the statutes, and we'll have the opportunity at the end to take some questions. Although I always like to put out there that if you have questions along the way, I'd certainly like to answer those as we're going through, because I would hate for someone to get lost midway through review of a legislation and not be able to move on until we get those questions resolved. So with that being said, if there are any questions at the outset about the process we're going to be following, I guess I also need to put the caveat, although we're discussing legislation and we're discussing the implementation of that legislation, this isn't legal advice. And if you have questions, you should of a legal nature, as far as how the law applies to a particular situation, you should direct those to your own legal counsel. That being said, I'm going to share my screen. Can everybody see my screen? I've got the OPI homepage pulled up.
Yes, Rob.
All right, well, welcome to the OPI homepage, opi.mt.gov. And I wanted to introduce you to a couple of places that you get information about tonight's event. One of the places is under Parent Resources. We've got both the past legislation that we've discussed available up here, as well as tonight's agenda, which Brenton had pulled up easier, as well as a short summary of the legislation. You can also reach this same information, depending on what your interests are, on our website by going to interim session updates. And down here, we have that same information available. So if you want to follow along with the agenda or the legislation summary, those are available to you by browsing to opi.mt.gov. It also contains some information about our next parent or our next community discussion night, which is about parental rights, and that'll be on September 20th, just under a month from now. But tonight, August 23rd, we're going to be discussing the Special Needs Equal Opportunity Act, House Bill 393. And a lot of our discussion is going to be about the language of the bill. There'll be a browse through what that bill looks like. And so if you have the opportunity, you can join me at the ledge.mt.gov. That's the legislative website. And let's just see how to pull up this bill so that you can read the language along with me. Under laws and bills, you would say that you want to look up a bill from this past session. Under the bill and house number, you would just type in HB for House Bill, and then you type in 393 and hit find. And this is a landing page that shows a lot of the background information about the legislative process for this bill. You can see that the bill was introduced fairly early in the session. Introduced on February 2nd, went through the House Education Committee and Appropriations Committee and various Senate committees. It was introduced by Sue Vinton. And I wanted to show you that up here, these two little icons, one of them is a link to an HTML page with a text of the bill. The other is a link to a PDF page with a link to the bill. And so we'll be using the PDF file. And so I'm just going to open that in a new link, and we'll be accessing that in just a minute. But I did want to introduce you to some of the other resources that are available on this page. The legislature, if a bill has a fiscal impact, they write a fiscal note. We won't be digging through the fiscal note at this point, but that is where the legislature has their information about the fiscal impact of a bill. There's also a legal review note. Not every bill has a legal review note, but this one does. And that's the opportunity for legislative staff attorneys to address legal questions about the bill. If we do get questions about those, I'm happy to open them up. But for now, I'd like to focus on the text of the legislation. So we opened up House Bill 393, and let me zoom in just a little bit to make it easier to read. And hopefully you can read that okay. So this is the actual bill, that the language that was passed by the legislature, and most of the bill contains new language. That is language that didn't exist previously in statute. There is a little bit at the end that contains language that amends existing law, but for the most part, this bill is dealing with new enactment by the legislature. And for context, I'm going to jump down to the end of the bill. Just so we can see what we're talking about. This bill has already become effective as of July of this year, but it doesn't apply to the current school year. Instead, there's a transition section right here, section 13 of the bill, that says that the legislature intends for this program to become operational at the beginning of the 2024-25 fiscal year. So that gives a one-year transition before this bill will be implemented by OPI and local school districts. Just wanted to point that out, that although the bill has taken effect now, the accounts aren't operational until the next school year. I hope that makes sense. Does anybody have any questions about the legislative process that led to the development of this bill, or about how to find the text of the bill? All right. Oh, go ahead.
We don't
Thank
have,
Oh,
sorry.
go ahead, please.
gonna
I'm
say we-
sorry.
I was just going to let you know, Rob, we don't have any messages in the chat box, but for those who are interested, Brenton Craigs from our legal team posted the interim committee out there
Take a
for
picture of it from our
the
website,
link for you to
the parent thing,
go
and have
to
that in.
check on the interim committee.
Okay, thank you, Jenna, and thank you, Brenton, for being around to help provide those resources to the members of our audience. So getting into the text of the bill, one thing that I wanted to point out is that this bill is a little bit unique because it is the legislature establishing an educational program pursuant to their prerogative under the Montana Constitution in Article 10, Section 1, Sub 3, and to navigate to both statutes and the Montana Constitution. You can go to leg for the legislature.mt.gov/bills/. montana.gov/mca/index.html. It's a lot to remember. You can just go to Google and type in Montana code and click on the first hit or two that says table of contents, and that'll get you to the same place that we are now. In fact, what I'm going to do is I will post a link in the chat. You can click on that link and it'll take you to the MCA homepage. The Constitution, was referenced there at the start of the bill. Article 10 of the Constitution has to do with education. And Article 10, I'm sorry, let me make sure I get to the right spot. Section 1, sub 13, sub 3, I mean. The legislature provides a basic system of free, quality public education. In addition, the legislature may provide for other educational programs as it deems desirable, and also educational institutions, public libraries. So this is one of the educational programs that the legislature is establishing that's in addition to the basic system of free, quality public education. And so that's referenced right there at the beginning of the bill. Section 1 just gives us the title. Section 2 gives us the purpose of the bill. Section 3 gives us the definitions that's going to be used throughout the bill and in the statutes. And we can talk about the definitions a bit more. But I really am looking forward to hopping right into the text of the bill, the meat of which starts here in section 4. And as necessary, we'll go back and check definitions. But really the central part of this bill is that it allows the superintendent to reimburse parents for the purchase of educational resources only for the benefit of the individual for whom the account was created, that is, the qualified student. And we'll get to the definition of qualified student here. But it's important to keep in mind that what this bill does and what this bill doesn't do. This bill does not transfer automatically funds to parents. Instead, what this bill does is establish a fund that those funds flow into. And when certain educational expenses are incurred, the parents can apply for reimbursement of the cost of those educational expenses. And to be clear, the legislature put right here, those educational expenses are only for the benefit of the individual for whom the fund was created. That is, only for the benefit of the student. This isn't a slush fund to benefit other types of activities. And so the legislature was very clear. And let's now go up and look at the types of students who are qualified for this program, because we have this understanding that this program is for those students' benefit. Qualified student means a resident of Montana who is a child with a disability under the IDEA, is between the ages of 5 and 19, is not currently enrolled in a school, but they were counted previously, is not currently enrolled in a school operated for the Montana Department of Corrections and the Montana School for the Deaf and Blind. And I should note later on in the bill, we'll also see that they cannot be currently enrolled in the local school district while they're participating in this program. But that they are eligible for enrollment in a school district, and they were counted the previous year for A and B purposes. A and B is an acronym for average number belonging. It's the term we use in Montana for the portion of, well, A and B literally stands for the number of kids, the count of the kids who are enrolled in public schools. A and B funding is the amount of money, the amount of funding that is based on that count of students. There are several types of funding available to schools, and one of them is based on the A and B count. So not to dwell on that too long, but there's a very specific definition of the students who are qualified for this program. So under this program, there is that educational savings account.
Rob, let's stop right now and see if
Sure.
there's any questions on the qualifications of section 3 of those students. I don't know if anybody has, Jenna. I'm sure you're watching to see if anyone has any questions. And Rob, you may want to reiterate again, because we are focusing on students here. What exactly is a qualified student? Just quickly, just review it again, please.
So real quickly, it's a student who is qualified as a child with a disability under the federal IDEA law, and they have to be eligible for public education in Montana, although not currently enrolled in a public school. A portion of that is described right here. They can't be with the Department of Corrections or the School for the Deaf and Blind. And then later in the legislation, it talks about how the students aren't enrolled in their school district of residence.
And Rob, so we do have a couple of questions. I'll start with the one in the chat box, and then Steve, I see your hand raised, so we'll unmute you just in one moment after we do this question. The question is, will the OPI use current staff to regulate the details of the new ESA, or will they engage with private entity to administer the day-to-day details of the program? If OPI, do they need to hire people to administer the ESA, or are there people already in-house capable of carrying out the legislative intent, meaning allowing parents to be the decision makers and reimbursing the parents' decision?
Okay, I can speak to that a little bit. I don't want to get too far ahead of myself, but let's talk about the funding for the program. So the funding for the program provides for 5% of the money to deposited into OPI Special Needs Administration account, the ESA administration account. And so that provides some amount of funding on an ongoing basis for the administration of the program. There is an appropriation, and sorry for nauseating you, but there is an appropriation for fiscal year 24 of $75,000 to OPI to administer the program. And then there's an additional $30,000 in the following fiscal year 25 to administer the program. So there's a tapering off of the appropriated amount, and this program is envisioned, I believe the legislature envisioned it to be self-funded through that 5% administrative fee. So then the question was, whether OPI would be staffing it in-house or contracted with an outside service. I don't know the answer to that, but Superintendent, your thoughts?
Thank you for that. And I also look at what you have on the screen here. This program doesn't go live, or we can't have special savings accounts set up until July 1 of next year. So within that period of time, understanding this appropriation and understanding the need of what the bills is asking for us to do to have this relationship with these parents, we don't know yet. This is all new. One of the things, though, that I am recognizing, and I want to be very careful with it, to have government make rules to implement the law is what this bill also does. It gives the Office of Public Instruction to give really strict guidelines, and that process is very bright and with a lot of sunshine to create those rules. to implement this program, which means then a lot of public input will be along the way. We won't do it in isolation. It will be something that will be in very bright sunshine. So more to come on this one, but great questions. And Rob, a great answer as well.
We have one more question, Rob, from Steve White has his hand up.
Hey,
Good
Steve.
evening. Thanks, Rob, and thanks, Jenna. Could you go back up to page 3, Rob?
Sure.
It's the section on definitions of, you have the subsection 7 qualified student, but that line right above it, as you know, I'm focused on homeschools, and I've been getting a lot of questions on this one. And at sub E, which is right above 7, says meets the requirements of Montana non-public schools under 20-5-109. And so the question I've been getting is that is this at all applicable to homeschools? I've been saying no, and the reason is that homeschools and non-public schools are delineated in 20-5-102, which there is a real separation, and they're defined up in 102. And so I'm assuming, I've been assuming that this is you're looking at 20-5-109, which is the exemption from compulsory attendance, that both non-public schools and homeschools both have to comply, except there's one section 5 subsection 5 that relates to homeschools. But homeschools and private non-public schools share the same section of statute. So 1 through 4, I think what this bill is doing is it's saying any school that is really following the precepts of 109, which is 1 through 4 for non-public schools, is eligible to be defined as a qualified school. If you go back to, as long as you got this on the screen, if you could go back and go to 102, or yeah, 20-5-102, and in the statute there, just one more. Okay, if you look down at the bottom of there of 2E, and this is what my point has been, enrolled in a non-public or homeschool that complies with the provisions of 20-5-109, which is the qualification for exemption. So here it says what a homeschool is, and then it says a non-public school is a parochial, religious, private school, etc. So I'm using this as sort of a foundation of telling people that this HB 393 is only relevant to the non-public schools as defined in this section of law, which is attached to 20-5-109, if any of this makes sense.
So Steve, I understand what you're saying. You're saying that you have to, I think I understand what you're saying. You're saying that you have to understand 20-5-102 to provide the context for what 20-5-109 says.
Yeah, basically the bottom line is homeschools are not qualified, not included as a qualified school. Only the non-public schools are. So homeschool is different than non-public school. So I just wanted clarification that what you see here on that, right at the bottom there, E, meets the requirements of Montana non-public schools under 20-5-109. So the students that are in a non-public school, which would be a parochial, religious, or private school, are the ones that are eligible for to be qualified students that would be eligible for the money in HB 393. So I've been telling people, I said, I don't think homeschools are part of this. I think it's just non-public schools. I wasn't a participant in the hearing, so but I think that's the intent. I didn't look at the fiscal note or anything to see what they said, but I just wanted clarification.
Okay, and just to make sure I understand the point is you're saying that this refers to the non-public schools in 20-5-109.
Yes.
And 20-5-109 refers to both non-public schools or homeschools.
Correct.
So your interpretation is that this doesn't apply to homeschools because it only refers to the non-public school portion of this statute.
Yeah, and what's really unique about Montana's law for non-public and homeschools is when they created this in 1983, there's 5 parts to it, as you can see. 1 through 4 are for homeschools and non-public schools. Part 5 is only relevant to homeschools. So when they referred to 109 in this bill, they're just referring to says, hey, if you're going to be a non-public school, you have to comply. You are complying with 1 through 4, and that makes you eligible to be a qualified school,
Okay.
non-public school. So
Well-
that's what I've been telling people. But again, it's just kind of weird because this only is relevant to ages 7 through 16, where this bill goes up to 19, and this section of law only kicks into gear for exemption from compulsory enrollment. And so, but they're still using this section of law. So it's kind of weird that way, but I understand what they're trying to accomplish. So, but anyway, that's just a minor point. But so anyway, I just wanted to make sure I was kind of on target there, that this is, if a homeschooler says, are we able to be part of this? I've been saying no, because it says non-public. It doesn't say non-public and homeschools. It just says non-public.
Okay, well, Steve, thanks for your thoughts on that.
Yeah. Thanks.
OPI hasn't taken a position on that interpretation, but it'll be interesting to see how this develops, not only with this piece of legislation, but of course, anytime you've got new legislation, there's always the opportunity for evolution over time, in future sessions from lessons learned, from the wording and the implementation. But I appreciate your view, you sharing your view on how this bill could be interpreted. Any other questions?
I think Rachel has a question. Rachel?
Well, hi, Rachel Dombach. So I am a homeschool mom with a special needs child. So I guess is the answer to my question, is my child eligible for these funds? And the answer is wait until OPI gets clarification. Is that the answer?
Well, so I appreciate the question. So the bill says what it says, but the superintendent mentioned, and I apologize, but I'm going to be doing a little finding here in the bill. Superintendent mentioned the opportunity for OPI to develop some of the implementation through rulemaking. And so let's just look at what that has. Establish rules necessary for administering the program that are limited to the following. And I believe that you're asking about the verification of student eligibility. And so, Rachel, there will be that opportunity for the superintendent to propose rules. And then, of course, we'll have our notice to the public and their opportunity to weigh in on those proposed rules. And so there will be a rulemaking process, and hopefully you'll participate and we'll be able to answer any questions that you have about whether that addresses your needs. So I guess the answer would be that although the language of the bill it may not be as clear as to give you the comfort of what it means, there is this obligation that the superintendent has to undertake that rulemaking. So we hope to see you and others as part of that conversation.
Thank you, Rob. And I'll just interject as well, from being in my legislative hat, I'll put that on. We can look at the intent of the legislator. So this was Representative Vitton's bill. We can also go back and review the hearing to see exactly what did come up, if there was anything that might give an indication of the eligibility. But I believe the rulemaking is very transparent, and you would definitely have that opportunity to voice that opinion of yourself to serve your child. And I believe that, in essence of what these meetings are about, is to get an understanding of what Montanans would like to see, given the parameters of the bill. But this gives rulemaking, which is a different manner of a deep dive of what these words really mean when we implement them. So moving forward, keep in touch. It'll be up on our website, and I'm sure there'll be a notice out for possibly another conversation community-wise as this. Jenna, is there another hand up?
No, but there is a question in the chat, and I'll go ahead and share that with you, Rob. This is from Anne. Are students only eligible for 1 year since they have to be counted on the district's A and B the prior year?
Yeah, that's a great question. And so I apologize. From time to time, I'm going to be hopping around to make sure that I get to the right sections in the bill. But there is this provision. If you look under section 9 of the bill, so this would be on printed page 8. There's this section 5. The Office of Public Instruction shall ensure that the participating student is included in the resident school district's A and B calculation in any year that the student remains otherwise eligible for inclusion and participates in the program. So the student is not enrolled and is not considered to be enrolled in the local school district, but the student, the Office of Public Instruction will ensure that student participating in the program is included in the A and B count, even when they're not enrolled in the local school district. Does that answer your question?
Rob, let's be a little clearer.
Okay. So yes, the student is counted in A and B for the local school district, for the residential school district, even if they're participating in the program.
Thank you.
Superintendent, I've got it pulled up. We were looking at the rulemaking regarding the administration of the program, but since I've got the search pulled up, I'm just going to hop down because there's one other section folks might be interested in regarding rulemaking. And that's regarding the accounting under this bill. The accounting will be through rules that you adopt. So folks, keep your eye out. The rulemaking will include both the administration of the program and the accounting. And I just wanted to, since we were talking about rulemaking, I want to give folks that heads up that it'll be on multiple topics. All right, any other questions?
I think we're good to move on. Yeah.
Yeah, so let's hop back up here, and we had started off with the section 4. That was the real start of the meat of the bill, and we were talking about how the accounts are established by OPI, and they're used to reimburse parents for those educational resources. And one of the things that I was talking about is that that money, it doesn't just flow to parents, it's only as a reimbursement account. You can see here the list of the types of educational resources that that can be reimbursed: programs, curriculum, tutoring, etc. And then there might be this question about what happens on the back end if all of the money isn't spent. That is addressed, that accounting is addressed here. Those funds are not refunded, rebated, or shared with the parent or the participating student in any manner. So that's consistent with the idea that really the purpose of the funds are not to flow to individuals. They are to flow only for reimbursement of those eligible education expenditures.
Rob, if I can stop you for a moment, Alba has a question. She's asking if this will this bill support dyslexia, speech, OT, or private tutoring services?
So tutoring is one of the types of services that is covered under here. As far as the specific eligibility of a student, they would have to be eligible under the Federal Individuals with Disabilities Education Act. And so if they have a qualifying disability under IDEA, they would also be a qualified student under this bill. Okay, so I'll just continue our stroll through the language of the bill. And if I'm trying to hit some highlights, but if you see some language in here that you'd like to discuss, please let me know. I'm happy to stop and share. So under parent responsibilities, one of the cornerstones of this bill is that the parents for qualified students must sign a contract with a superintendent of public instruction. We've got to make a deal, we'll say, about how this program is going to be run and how these funds are going to be spent. So it'll define the obligations of the parents. And you'll see here that one of the obligations is to utilize those funds in an appropriate way. They've got to release the resident school district from the obligation to provide FAPE, the free appropriate public education, to that qualified student. They've got to submit copies of receipts to the superintendent of public instruction. If the qualified student is re-enrolled in a public school, they've got to notify the superintendent. And if the student enrolls in a qualified school, those students need to remain in attendance and they've got to comply with the policies of that school. So it's more than just a requirement in the statute. The statute actually requires that this contract be made between the parents and the superintendent in order for those funds to be, those education expenditures to be reimbursable. So looking at the responsibilities of the superintendent, we've already looked at this section a little bit when we were looking at the rulemaking responsibilities that the superintendent has. But there's also some other things. I'll just highlight a few. The superintendent must be basically transparent about the program and the process. So as you said, superintendent, people can look to the website for information about the program and how it's being administered. It has to recognize the placement of the student, of the qualified student, by the parents as a placement under IDEA. Superintendent has an obligation to remove qualified students if there's misuse of the funds. For example, non-reimbursable expenses are submitted as reimbursable expenses. And that also includes this oversight of the funding. The accountability of the funding includes potentially even a referral to the Attorney General for further investigation. So there are significant obligations the Office of Public Instruction has to ensure the integrity of this program. We discussed already the rulemaking authority of the superintendent, or obligation of the superintendent to administer the program. But if there are any questions about these sections before we move on, about section 6.
I don't see any questions, Rob.
All right, well, moving on to section 7. The local school district has an obligation to participate by ensuring that the student records are transferred as necessary for the student who's participating in the program. I want to highlight this portion. So those participating schools, one of the mechanisms of oversight established by the legislation is that they are required to submit quarterly reports to the superintendent of public instruction about the services they're providing. there are other provisions in there, but I just wanted to highlight that accountability that the qualified schools have to also be transparent about what they're doing as far as the provision of educational services. Any questions about section 8?
Rob, I just want to highlight that word you said about accountability. I believe in the very beginning in our chat, there is a question of accountability. And I believe it's accountable from my office, from the Office of Public Instruction, as well as there's accountability with the parent that you just had shared with in the previous section. And now there is accountability with this participating school district. So I think that's one of the things that, whether it's ingrained in the bill or not, can also be strongly stated within the rulemaking as we apply this moving forward. And because of that transparency and the bright sunshine that we have in participating with the public, I think it's extremely necessary that this is a brand new thing that the state of Montana is embarking on. And we make sure that students are being served in a manner that's transparent, as you said, as well as highly accountable to whatever entity that those taxpayer dollars travel to or travel from.
Okay, thank you, Superintendent. In order to discuss section 9, I do want to hop back up to the definitions and talk about this definition, the ESA student amount. And the combination of this definition together with section 9, so let's just get down there, establish the funding formula for this program. And I don't want to get into the details of that because they're pretty self-explanatory if you take the definition that's in up in the rule in the defined definitions portion, and you'll place it in this this formula that's in statute. But at the end of the day, a portion of the funding that goes to school districts for that student are what is eligible to be placed into the education savings account fund that's established under this statute. And that calculation results in the, and I just want to make sure I highlight the right portion of this. In the resident school district remits that portion of the payment that's calculated to the Office of Public Instruction for holding in trust as part of that, or as the funding for that education savings account. And we talked about this earlier, but it bears repeating that the accounting for those funds are going to be established by rule by the Office of Public Instruction. And I had, we've already talked about much of this. 95% of the funds are available for the reimbursement. 5% are available for the administrative expenses. We also talked about how the student will be included in the A and B count. So we've already covered a lot of the ground. In section 9 of the bill. Does anybody have any questions about section 9 of the bill? All right, moving on to section 10. This is this identifies those education savings accounts as trust accounts. And the legislature was very particular about ensuring the integrity of these accounts, identifying them as trust accounts and providing that the assets of one account may not be commingled with the assets of another account. So each account stands separately as a separate trust account administered by the state for the benefit of that participating student. It provides a lot of um, surety in the integrity of that account, since they're each individually separated and not commingled dollars.
Rob, if I can interrupt you, we have another question from Trish. If this is to be up and running in 11 months' time, when do you expect registration to be open, and how will parents be notified of this option, giving them the time they may need to make tough decisions and find alternative educational services and/or schools?
That's a great question, and part of that I'm going to let the superintendent address, but part of it I want to note is accounted for right here in the obligations in the statute, where it says the superintendent public instruction shall make information about the program, etc. Printed materials through the website. I also know that our office and the superintendent participate in public conversations and forums, radio shows, through press releases and newspaper articles. Superintendent, I'll let you address some of those ways you speak to the public about our programs.
Thank you so much. Great question, Trish. And that's why we're holding it now. We do have 11 months, as the statute says, to get this up by July 1 of the following year and ready to go. And it's about our students and being served, but it's also making sure that our public schools recognize this, and also our providers in our communities as well. And we are a very diversified state because of our geographic locations. We're very small and very rural, frontier by federal standards. So it's now. So we're beginning this discussion now and trying to see exactly what does this mean, so we don't come at the end. But as this new year opens in the next 4 months, we want to make sure that we are being prepared with great information in many, many different facets, and know that who we serve are our kids. And most importantly, making sure that all students have that ability to learn. So we're on it. That's why it was noted here today all by itself, so that we could understand you and your questions you might have, so that we can better implement. So more to come.
And Superintendent, I think one of the other mechanisms that that OPI uses is not just those communications with the public, but I think that you've got your newsletter that a number of school district administrators read around the state, so that they can be prepared for their obligations under this bill.
Perfect. And I also see Trish also put into the chat box that it's about the services. So if indeed the services are in a community setting, they may not be as robust as need be. So the sooner that we can get this up and running or implemented with whatever rules or explanations given the language in the letter of the law, the better that our providers in our communities can start serving or be recognized by families and schools. So it is important that we have these discussions now and make sure that we have something firmly committed in the earliest as we possibly can before implementation. Thanks, Trish.
All right, so the remainder of the bill is just that we haven't discussed. We actually have discussed a portion of it. That was the end of the sort of new part of the bill. There is the one statutory amendment to account for the funding, and then we looked at the end, the appropriation to have the program up and running for the first 2 years, the transition period, and et cetera. So we're at the end of the bill, and before I close the bill's language, I just wanted to give folks one last opportunity to ask about any of the sections that we had a chance to look at here this evening.
Rob, there is one more question in the chat box. I'll share with you from Alba. Will special education curriculums be eligible, for example, a student with dyslexia that needs to utilize Orton Gillingham program and the parents homeschool? Will that be eligible for reimbursement? I understand we are still determining the homeschool part, and we may not have the answers, but I'd like to add that we would really support students that cannot get those types of services in their public schools and are having a hard time with IEPs. So more of a comment and a statement, or a question and a statement.
All right. Well, let me break it down. There are two primary parts to this question that I'm hearing. One, again, has to do with the qualified student. And so if the student meets the IDEA qualifying requirements for a child with a disability, then, and that's under this definition here in section 3 of the bill, then the types of education resources that can be reimbursed are listed down here in section 4. And that includes, I noticed specifically, curriculum and supplemental materials for curriculum. So, we want to make sure that the student is a qualified student, but if so, then that's the type of expense that can be reimbursed under this program. One of the types of expenses.
And then there's one more question, Rob, if we have time for it.
Sure.
This is from Arlene. Will OPI provide for parents a list of eligible schools and analysis of the efficiency of programs in various schools and other information to help parents find appropriate evidence-based programs?
So the statute, the legislation doesn't have an obligation for OPI to provide a list of schools. And there's one thing that I really want to make sure that I didn't emphasize it before, but since we're getting the question, I want to make sure we address it now.
So Rob, let me interject while you're thinking there.
Yeah.
We have a unit at the Office of Public Instruction because we accept federal dollars of IDA, their special education funds. And so we've got a great team that recognizes schools and how schools serve. It's not that there is a requirement to put a list up, but what I would help, and we can put up on our website, anyone within our special education unit to be able to better serve. Another thing that we are recognizing, not just because of this bill, but because of serving all individuals. Jenna McKinney on here that you see is our parent liaison. And so we have robustly encouraged parents to visit with her across our state on positive issues, issues they may be challenging for children of any kind of needs. But we have just opened up an application in special education for that parent liaison. And that means then that parents that may have a challenge of whatever it might be in how a school may serve, or in better communication, or just getting a structural question, we'll be able to have that portal here at the OPI to have that parent-to-parent view. And I believe that's going to be very instrumental in implementing this bill, but also many others and many other questions that we have. We have in Montana about 13% of all of our 160,000 students that we serve in public education are determinant in an IEP or a 504, something that looks a little bit different in that individual delivering of education. So I believe we've got great opportunities moving forward, and this bill is going to help us even better serve.
Well, thank you, Superintendent. And I wanted to note that although there is not that specific requirement for maintaining a list of schools, the legislature was very cautious about OPI and other entities not over-regulating those non-public schools. And they specifically addressed that in this portion of the bill may not regulate the educational program of a qualified school. So they maintain that separation between the private school and the ability of OPI and other state agencies to regulate it. So I don't know that I have a list. I'm not sure who has a list, but that list is going to ensure, or those schools are going to ensure that their programs are independent. Any other questions? All right, seeing none, I will stop sharing my screen and we can, Superintendent, any final closing remarks?
I thank you. Thank you very much. And Rob, good job. I didn't get too busy with the scrolling that you did, but I very much appreciate how you taught all the way through from the origin of the bill to the end of the bill with this. Just want to share that we are here to help serve. We are here to help invigorate the lives of all children across our state. And I want to give a big shout out because on this call, I've got some great OPI employees that are specifically here to serve special needs children. And they just represent many that are behind them in the unit here. We are here to serve all children at the Office of Public Instruction. And we're blessed that parents were here, blessed that we had a homeschool view. And if you have any other further questions, I'm here to be available for any opportunity that you have. With that, blessings to all of you. The school doors are opening. Let's make sure that this is the best one for our children and a very safe one as we move forward. And we want to honor our teachers for all the good effort that they are contributing to the education of our students. So blessings to all. Stay well. Thank you.